Hello and welcome to today's Ask Andrew show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the principal and founder of the GTA family law firm, Feldstein Family Law Group. Both myself and our entire firm practice exclusively in the area of family law. We have offices in Markham, Vaughan, Mississauga, and Oakville. Today, I'm joined by one of our associates, Lauren Harvey. Lauren, welcome to the show.
Thank you, Andrew. I'm happy to be here.
Today's topic is how to change a final order or a separation agreement in a family law case. If it doesn't apply to you, I understand why it may not sound like such an exciting topic. But if it does apply to you or one of your loved ones, it actually becomes a very, very important topic, because when you feel that you're paying too much money, or you're not getting enough, or you're not seeing your children enough, or you want to reduce what the other parent sees the children, all of these issues become really burning issues that for a lot of people becomes one of the most important things in their lives. So today, that's what we're going to talk about. So, Lauren, as you know, a court order is a decision made by a judge that requires a party to do something or not do something. And someone may want to change that final court order. How would you go about changing a final court order?
So really the first thing that you want to do with a final court order is assess kind of what has been the material change that's occurred since the final order was made. That's typically the threshold that you're looking at. So if we're just talking about a final order and not a separation agreement, typically your first you would have to bring what's called a motion to change, which is basically a pleading that you bring in order to change a final order, wherein you explain the reason for the change, what your proposed change is. Now, if you and the other party agree on whatever the change is, whether it's a change in support or a change in the parenting, you can do what's called a consent motion to change, which is a little bit more of a streamlined process where you essentially fill out the form on consent of both parties and submit the order to the court to be issued. Really, the difficulty becomes when you and the other party don't agree on whatever the change is, and then it proceeds back through the court system by way of a motion to change.
So one of the things that you're entirely correct that you said is typically the threshold is a material change in circumstance. And it's very important to focus on those words, typically, because typically if you want to change a parenting agreement, or I should say parenting order, you need to have a material change in circumstance. But it's important as a lawyer or as a self-rep to start with the first principle of look at your final order.
Yeah.
Because this is how to change a final order. Sometimes there will be a different threshold that you need to establish in order to change, for example, the parenting schedule. Now, the fallback of the law is material change, like Lauren said, but what could have happened is 2, 3, 4, 5 years ago when the parties were litigating, because they were, if it's a final order, they had agreed to a different threshold. They could have agreed to review it, and there's a Latin term called de novo, which means as if it's fresh. So it's always important to go look at that original order, go look to see what the original test was. And if it's about parenting, you start assuming it's material change. If it's about spousal support, you start assuming the threshold is material change unless it says something different in an order. But child support is slightly different in that typically there's a review of child support that takes place every year to ensure that someone is paying child support in accordance with the guidelines. Okay.
The other thing I should clarify is you also, like you said, Andrew, absolutely correct. You want to look at what the terms of the final order are. You also want to look and see if there's anything in the final order that tells you what process to follow, right? Perhaps, I guess this may come more in effect if you have a separation agreement, but there might be dispute resolution terms that say you have to negotiate for X amount of time before you can litigate, or you have to do mediation or mediation arbitration before you litigate. So you want to look and see whether those processes are outlined to ensure that you're following the correct process before you potentially go down a wrong path.
And that's a really great point. And the other thing that becomes important if you're about to embark on this process is make sure that you're in compliance of the court order if possible. What do I mean by that? Well, if I want to reduce my child support, I should be giving my financial disclosure before I even try to take it to court. A, I'm going to be obligated to, but B, you really look bad when you go to court and say, hey, I want to change something and I never gave you any information to assess it. So there's issues there that you got to become aware of and make yourself aware of. Now, as we work our way through, one of the things that I always think of, and this is important for us lawyers to do, is what the Supreme Court of Canada has said about changes, is that a material change is only material if it's not foreseeable.
Right.
And do you want to explain what that means?
So essentially, it means that at the time that the final order was entered into, if a change was foreseeable, as in the parties acknowledge that it could happen, that may not meet the threshold of being a material change. That's what I believe you're saying the Supreme Court of Canada has held. So it kind of puts a little spin on what will actually classify as a material change.
So what that means, and I always think of the case where somebody is now repartnered or acknowledged that they're engaged or may remarry, and they negotiate a parenting schedule, and then after they have their final order, say a year later, that they get married and a new partner moves into the home. Well, from a parenting perspective, a new partner moving in would be a material change. However, if you had disclosed, and in one case I'm thinking of, the Office of the Children's Lawyer was involved, and they knew that this person had a fiance and it was contemplated this person was married, it was a clear, or getting married, it was a clear record. They said, well, we're not going to even investigate whether there was any need to change the schedule because it wasn't a material change, because this was foreseeable. What does that mean for us as lawyers? It means that when we draft agreements, or we have the opportunity to draft the final order because it's in accordance with minutes of settlement, we put in that the material change is foreseeable or not foreseeable, because we want to cover that potential argument. Because as you read the cases about what is foreseeable and what isn't, it becomes a large part, some wordsmithing is done, because one could argue retirement is always foreseeable. Even when you're 30 years old, retirement is foreseeable, but the courts will typically deal with that differently, but maybe not as you get closer to the retirement date. So there's various issues that we as lawyers have to think about when we're trying to have that crystal ball in terms of what's foreseeable or not foreseeable, especially ensuring that those words are there, and appreciating that if something was foreseeable, that may mean you don't meet that threshold of there being a material change. So that's one area we get to. Now, we talked a little bit about it, but what is the first step that a person generally needs to take if they want to change a final order or a separation agreement? And is there a difference in terms of the steps they need to take if it's a separation agreement versus a final order?
Yes. So like we said, if you have a final order and you're looking to change it, you have to do it by way of a either consent motion to change or a motion to change. When we're talking about a separation agreement, we really have to get down to what issue is it that we're trying to change. So, for example, if you want to change support terms in a separation agreement, in order to bring the motion to change, you have to file the separation agreement with the Family Responsibility Office, which is a government agency that assists with enforcing support obligations against payors. So, however, what that means then is the Family Responsibility Office only deals with support. It doesn't deal with parenting or any other issues. So when you have a separation agreement, if you're bringing a motion to change, it's only about the support terms of the separation agreement. If you have a separation agreement and you want to change a parenting term, you can either do an amending separation agreement if you want to try to negotiate with your ex-partner, or if you need to litigate the matter, then it's a fresh application that needs to be brought. So it's important to kind of know where what exactly issues are you trying to address, because the process that you have to follow may very well differ.
And it quite frankly, it gets even more contextual because an agreement is not necessarily given the same weight as a court order. So when you bring that application to change the parenting schedule, the agreement may reflect that the test is a material change to change the schedule, but the court isn't necessarily bound by the agreement. The court has the obligation to determine what's in the best interest of the child, which is different than having to establish material change when there's a final order. So there's some very nuanced contextual issues that go with this. And I used to sit for 8 years as a dispute resolution officer in Newmarket, where I would do the first case conference on these motions to change. And it's quite surprising to see how many lawyers don't appreciate the difference between a motion to change over support and a motion to change an agreement regarding property. And it was a number of times I would have people in court and they wouldn't appreciate that they came to court over things that were a nullity that the court had no jurisdiction to deal with, and they had to fix it. They had to fix that problem by going and doing an application. Usually the problems will get fixed, but it's also really embarrassing when you do it the wrong way and you're
sorry, Andrew, and time consuming and cost consuming. So yeah, it's important for sure to understand the process. And that's where it also is a good opportunity for right in the beginning when you're contemplating changing a separation agreement or a final order, is sit down and say, what is it really, my list of things that I want to change, and then make sure that you understand the process whereby to seek those changes to avoid the situation like you were talking about, Andrew.
Which is really good advice to any of our viewers who are watching. I will note this, the forms for a motion to change are supposed to be straightforward. They're not. They're far from it. They don't read very easily, but that's life. Now, the process, people need to appreciate different courts in Ontario will have different processes. Some will do it a certain way, others will do it a different way. Most courts, in my experience, start when you have the motion to change. You need to understand that is an originating court process. That means that your materials are treated the same as a court application and have to be personally served on the other side. And I would always say to a litigant, don't do the service yourself. You're asking for trouble if you do it yourself. So they have to be personally served to start the court action. The other side has 30 days to do an answer, and you're going to have to attend a mandatory information session. You're going to have to go to a first appearance. And do you want to talk about what the first appearance typically looks like?
Sure. So typically first appearances, it's more really a procedural appearance more so than anything else. Essentially, you're in front of a clerk of the court who will confirm that all materials have been filed. So that the motion to change in this case and whatever proof of service has been properly filed with the court, that the other side's response to motion to change has been filed with the court. They're basically making sure there's no issues with the filing of the materials. Some courts would be willing to give some dates for a possible DRO conference, which is typically in most jurisdictions, I think, the first step where you go to when you're doing a motion to change, which is essentially a version of a case conference in front of a dispute resolution officer, as Andrew was talking about before. So some clerks are willing to give dates at the first appearance, and other times you have to reach out to the court personally, like the trial coordinator's office, to get those dates scheduled.
Now, what's important to understand is a dispute resolution officer is a senior family law lawyer. So it's not as if you're going in front of somebody who doesn't know it. A lot of very good, capable lawyers do it. It's a way that we give back. That's why I did it for 8 years. We're not judges when we do that work, so we can't make orders, but we write what would be called a screening report. And the first thing a judge will typically look at when you get in front of a judge is what did the DRO write at the screening report? And it's a really important event because if someone is having, I would say, poor litigation behavior, my screening report when I did it would usually reflect that. If somebody wants to think, well, I'm just appearing in front of the DRO today, so I'm going to be obnoxious or take really unreasonable positions, there's a consequence that I always remember. I was sitting there as the DRO one day and a senior lawyer was sitting there and he said to me after I gave my thoughts, and he was playing every delay game under the sun. And he said, well, Andrew, we both know I'm not going to get a case conference date for 5 months, so I really don't care what you say, and my client won't be producing the child for another 5 months until we get the next date. And I don't know, when someone says that to me, I don't really like it much. And what people need to understand is when you are the DRO, you have very good access to judicial resources that day. So I held the matter down. I go into chambers. I speak to the judge. I come back out and I tell both parties that in 5 minutes they're going to see a judge who now can make a court order, so things will happen. And the judge heard all about how this one lawyer took this very obnoxious position. And he apologized to me as soon as I said that, ironically. But the point is, don't underestimate the date because you're dismissive that it's a lawyer. The lawyer can write a negative screening report. The lawyer may be able to put you in front of a judge that day if they really think it's urgent. And when someone's not going to see their child for 5 months, that to me is urgent in my experience.
There are matters, like you said, you're speaking with a senior family lawyer. So there are matters that could potentially settle at the DRO conference stage, right? So I definitely agree with Andrew there. Sometimes you can get the DRO conference date much quicker, and it definitely should be capitalized on as an opportunity to really address the matter in the hopes of kind of avoiding future litigation.
Now, the other thing, taking a step back to the first appearance, it's for the court registrar to make sure the case is ready for the DRO. That's what it's really for. And then when you go to the DRO, if you're not going to resolve it, and a lot do resolve it, like Lauren said, at the DRO case conference, it's incumbent on the DRO to get the case ready to move forward. A number of times people would come back and see me 2 or 3 times to help resolve the case, and I was happy to do that. But if they want to get in front of a judge, that's fine. But it was also incumbent on me to make sure the case would be ready. That means I really wanted people to have the discussion about disclosure and what they needed to do and what steps were needed in order for them to be ready for the next stage of a case conference in front of a judge, settlement conference in front of a judge, or a motion in front of a judge. So this route of having the dispute resolution officer, it may sound a little less formal, but at the end of the day, it is an important event. Now, the difference we spoke about is if it's a parenting schedule and you have an agreement, you're going down a different road now. And do you want to explain a little bit more about that?
Sure. So like Andrew said, if you have a separation agreement with parenting terms and you're looking to change them, the avenue that you have to go through is a little bit different. You're not doing a motion to change anymore. What you're doing is basically a fresh application. And the forms that are required with that. So then you're following a little bit of a different court process. Your first court appearance is going to be typically, I should say, a case conference in front of a judge where the issues are canvassed. Again, eventually you'll still get to a settlement conference. Eventually you may need to bring a motion, but where you start and the forms you have to fill out are different, which is why, and we keep harping on this, it's important to really narrow down what is it that you're trying to change, because if you bring the wrong originating process or the wrong process, it really is just going to slow the matter down. And if this is something you're seeking a change for, you likely would want it done expeditiously.
Now, what I always found interesting when you get into these motions to change is when the rules were changed, family law rules were created, I think it was 1999, way before Lauren was a lawyer, but after I was. And when it came in and we saw a motion to change, we all thought it meant that these would be governed by a motion because it's called a motion to change. Doesn't happen that way. You end up, if you don't resolve this matter, you end up going to trial.
Oh, yeah.
Just like you would if you had an originating process of an application. And one of the things that makes this so difficult sometimes in a motion to change can be how many years are you fighting about? Sometimes we have retroactive support issues going back 10 years and movement of children in and out and spousal support going up and down. And you may have a self-employed individual. And if they are, they may need an income report for all those 10 years. So don't fool yourself into ever thinking it's a motion to change. It's really simple. It's going to be easy. It's going to be quick. It's going to be efficient. Nothing is quick, easy, or efficient once you engage in the court system. If you engage in alternative dispute resolution, that may give you the advantage of a quick and easier resolution to your case, but don't expect that when you go to court. Okay, now, a common modification of a final order is seen in family laws in regards to spousal support payments. How can a payor demonstrate a material change in circumstance that would justify modifying the final order?
So again, the first thing that you want to look at is there any terms in the final order that classify what is versus is not a material change? So some of the common ones that we see is if the recipient spouse remarries, it might be constituted a material change. If the recipient spouse is living in a relationship or cohabiting with someone in a relationship of permanence, which we typically say is around the 3-year mark. Like you said, retirement is one that we often see. If the payor has a health issue or potentially recipient has a health issue that prevents them from working or impacts their ability to work. So those are kind of the common ones that we see, but there certainly could be others in unique circumstances.
Well, I certainly agree with and echo everything you've said, and I'm going to give some qualifiers to it, as probably I often do. Some people like to think that just because their former spouse got remarried, that they get to look up at the sky and say, hallelujah, I don't have to pay spousal support anymore. I'm one of these lucky people that's getting a clean break.
It triggers a review.
It opens the argument that yes, there was a material change. It doesn't mean the spousal support is going to go from, it could be 30,000 a month to zero.
Yeah.
The first part of the test was there a compensatory element to the spousal support claim? If there was, then you're less likely to get a significant reduction. If it's needs-based, then you're more likely to get the reduction, which begs the question of, what if you're a payor, do those horrible words of compensatory mean? And what if you're a recipient, are those glorious words of compensatory? I often believe the easiest way to explain something is with an extreme. What's an extreme? You have 20 years of marriage, you had 2 or 3 kids, one person went to work in what would be viewed as a traditional marriage, and the other one raised the family. Clearly, there's compensatory support there because the person gave up everything for that marriage. Contrast that with the 20-year marriage where a person took a couple of mat leaves, they were a teacher, now they're a principal. Where's the compensatory support in their claim? Because how is that marriage create an economic disadvantage to that person, notwithstanding the fact maybe they were the primary caregiver, but their career was advanced as it would be. So we get into some really interesting arguments with compensatory support, and that becomes highly relevant on the remarriage or common law. Now, often we also have a problem of establishing once someone has been living with somebody for 3 years, because as you can imagine, when there's a high-paying spouse support claim, people try to deny that they're living with somebody.
Yeah.
You end up with private investigators trying to see how often that person lives there, knocking on neighbors' doors, seeing where their car is. The car goes in the garage at night. You see them leaving for work in the morning. There's a whole host of factors that you try to do, but some people will deny the common law. You talked about retirement. That's another big one that we often hear. There's 2 types of retirement. One is voluntary and one is involuntary. How old is the person who has the voluntary retirement? What's the normal retirement age in their business? Remember, if you're going in front of a judge, judges get to work up to 75 years old, and a lot do. Maybe only half time, but a lot do. So when you say that you're 57 years old and you want to be done, that may be a problem for you. May not be. Maybe you've always had the plan. Maybe you have the financial resources that make sense. And being retired is the starting point. The question is going to be, what income do you have once you retire? Do you have some retirement income? And what are the assets that are generating that income? Right. Were they already used to equalize with the other side or not? If they weren't, their income for support. If they were, they are. Like the thing I always think of, somebody says, Andrew, I got an inheritance. It's $5 million. I don't have to share that with my spouse, right? And the answer, as you well know, Lauren, is no, you don't have to share it. However, if you invest it and you get a 5% return on it, that $250,000 is income for support.
Yeah.
So these are some interesting areas we get into. And one of the things I often say to people, I think of judges who have said this to me, is you picture the 62-year-old mid-level manager who gets laid off from work, gets a package of a year. Now they're 63 years old and they're bringing their motion to change. Because when you get your package as part of your termination, that counts as income for support. And when that comes to an end and you haven't found a job, now you're going to go to court and say, I have no income, I can't pay support. What do you think happened? What would you say is going to happen then, Lauren?
They're going to probably, I mean, like you said, you have the burden. If you're the one who wants to seek the change, you have the burden of proving that something has actually happened to justify that change being made, right? So if you are retiring, they're going to look at, do you have, like you said, Andrew, other sources of income, right? Potential that wasn't already equalized on, right? So they're not just going to look at, okay, so you're retired and that's it, and support will end. They'll look at, is there other sources of income that you have, and is there kind of still a support obligation based on that?
And the scenario I gave you was a 62-year-old who's now 63,
Yeah.
and the spouse says, but I need that support to live. And we're in a position of saying, but if they've shown us a year of job searches and they can't find any work because they're 63 years old and nobody wants to hire them, you're going to be hard pressed to find a court that's going to say that's not a material change and to say
Right.
this person has to pay support.
And like you said, it depends on the age of somebody too, right? I'm sure everyone can appreciate at 62, it's going to be difficult. Depends on the industry too, right? Like you said, what is the industry like, right? How often, how old do people typically work in that industry that they're in? If they work until 65 and somebody's 62, the question is kind of, are employers going to want to hire someone for basically just 3 years? Right. So, like you said, yeah, those are all the things that you want to be able to have the evidence to bring to the court and demonstrate, this is the industry that I'm in. This is the typical retirement age. This is my circumstances now, so to demonstrate that it is actually, in fact, to maybe retire what would be a little bit earlier than what may be considered as normal in that industry, if you're seeking a reduction in support.
Now, the other place that you may seek a reduction in support is that we look at the SPUS Board advisory guidelines, which give a duration. There are two things: when you're the payor, you're the loser. When you're the recipient, you're the winner. Rule of 20. That means your duration of cohabitation and marriage, if it adds up to 20, you're entitled to indefinite spousal support subject to a material change in circumstance. Or the rule of 65, which says add up your years of marriage in common law plus the recipient's age at the date of separation. If that's over 65, providing you've been together for at least 5 years, then it's also indefinite.
Yeah.
So that doesn't mean you're paying the rest of your life. It's still
I was just
subject
about to
to
say that.
change.
Yeah, it essentially means indefinite subject to variation or review, which is where we get into this, material change in circumstance, right? So it may be indefinite until maybe someone loses their job, or maybe somebody retires, or there's a health issue. So I think that's one of the things that I often have to dispel with my clients is indefinite does not mean for the rest of your life, right? Or it doesn't have to mean for the rest of your life. There's always this, it can be varied, reviewed upon a material change, but it just means there's not going to be a set duration at this time.
And the last point on that note is if you don't hit the rule of 20 and you don't hit the rule of 65, the spousal support advisory guidelines are going to give you a duration, which is typically half a year to 1 year of the common law and marriage time combined. That means if you were together 12 years, you're looking at 6 to 12 years of spousal support, which means someone may bring a motion to change once they hit that 6-year threshold, even though the quality of the case is better as the years go on. But as they hit that range between 6 and 12, they may be arguing they've paid enough of the duration that should establish perhaps a step-down approach to termination, terminating now, but it opens the door for a discussion, which is the other type of material change you may see a motion brought for. So there's some really interesting issues, even though I started off by saying it may not sound like such an exciting topic, but it is when you're the payor or you're the recipient and your livelihood is dependent on this, or a good chunk of your money. I'm going to end by saying we hope that the viewers got an idea and learned a little bit about changing a final order. or a separation in an agreement and how that works in a family law proceeding. Lauren, thank you for joining us today. You did a great job.
Me. Thank you.
The next Ask Andrew show will be on Tuesday, August 29th, 2023 at 12 noon. If you have any questions or ideas for shows, please email them to us at info@feldsteinfamilylaw.com, and thank you for watching.